working? Looks like it's working. Welcome to the Voting Rights in America panel. I have just a couple of quick announcements before I hand it over to the presenters. My name is John Wheeler. I work for the Iowa State Bar Association. I direct their Center for Law and Civic Education. I'm happy to have a program here that works with students and teachers and links with the legal community around the state. There are two things that I want to point out to you. Number one, while the presentation's going on, I would request that you keep your audio muted. That way we eliminate some of the background noise. Whether you enable the video or not is entirely up to you. The second is that there is a web page that we've created on the iowabar.org website that includes resources, videos, materials relating to voting rights in America. This video, as well as the PowerPoints that are going to be used today, will also be loaded to that website within a day or two. So for anyone who would like to refresh their recollection or who missed being able to be part of this program live can look at it over the internet. And finally, if you have questions, and I certainly hope you have questions, feel free to submit those questions via the chat function on the bottom. You'll see the quote bubble, and there are two ways that you can either chat. You can either chat to the group as an entirety, and I will keep a note of what those questions are, or you can send your chat question directly to me, John Wheeler, and I will again make a note of those questions when we have time during the presentation or at the end of the presentation. I will recognize the specific person asking the question, or I will ask the question on your behalf. So with that, I'm going to turn the program over to Jerry Schnurr. Jerry is the president of the Iowa State Bar Association and is an attorney in private practice in Fort Dodge. Jerry, it's all yours.
Thanks, John. I want to welcome everybody to this first panel that we plan to put on this year. This is on voting rights in America. We will hear from our presenters today, which will cover voting rights brought up in the 15th Amendment, the 19th Amendment, 24th Amendment, and 26th Amendment of the Constitution. As many of you probably know, this is the 150th anniversary of the 15th Amendment and the 100th anniversary of the 19th Amendment. The 15th Amendment, which we will hear about, is the amendment that granted former slaves the right to vote, was enacted shortly after the Civil War. The 19th Amendment is the amendment that gave the right to vote to women in 1920. And then we will hear about the amendment that granted 18-year-olds the right to vote. Before that, it was 21. Our presenters, in the order of presentation, will be Emily Chafa. Emily is an administrative law judge, former administrative law judge with the state of Iowa. She is an attorney and a member of the Iowa State Bar Association. She is also the chair of the Iowa State Bar Association Diversity and Inclusion Committee. Henry Hamilton is the vice president of the Iowa State Bar Association and is a federal administrative law judge. And then we have Anjela Schutz, who is an attorney in Des Moines. She is the president-elect of the Iowa State Bar Association. And so we are happy that you are all here, and I'm going to turn it over to Emily Chafa, and she'll give us some background and get us started. Emily, take it off.
Thank you. We'll go ahead and start with the names of the presenters and the amendments that we're discussing today. I must also mention the disclaimer, especially since this program is recorded and some of you may be viewing it after this date. So first of all, these materials and statements reflect our own personal opinions and interpretations and do not reflect the views of any past, present, or future employers. And then, as you'll hear later on in this presentation, voting rights issues are occurring, reoccurring, and changing on almost a daily basis these days. So these materials and statements are current as of today's date, October 12th, 2020. The laws, policies, and practices relating to voting rights may change. Let's go back to the very, very beginning. The Declaration of Independence, July 4th, 1776. Of course, we've read this first sentence many, many times. As you probably all know, Thomas Jefferson wrote the Declaration of Independence. In this initial sentence, he said, "These truths are self-evident that all men are created equal." Let's think about that for a minute. All men are created equal. When he wrote those words, he didn't really mean all men. He meant mostly white men who were property owners. And some of the property that some of those white men owned were human beings. So in the Declaration of Independence, thinking about voting rights, all men really just meant a small group of white men who owned property. Let's move on a little further into the future. The U.S. Constitution, adopted on September 17, 1787, many of the same white men who participated and signed the Declaration of Independence were still involved in the Constitutional Convention. Here the language is a little more inclusive, and I'm sure this language is very familiar to many, if not all of you. The preamble to the United States Constitution says, "We, the people of the United States, in order to form a more perfect union," and so on. Who did we, the people, actually mean in 1787? It meant white men who owned property. So we, the people, did not mean men of color. It did not mean women. It did not mean persons who were currently enslaved. We, the people, really just meant a small group of white men. They were the holders of all the power and specifically voting rights. Let's fast forward a little bit through the United States Constitution. Article 1 is basically the legislative branch of government, our elected officials. This section just illustrates that this small group of white men were voting for their representatives and then, of course, held all of these elective offices. Now let's fast forward 100 years or so. The 13th Amendment to the U.S. Constitution, ratified on December 6th, 1865, the end of the Civil War, clearly prohibited slavery. Neither slavery nor involuntary servitude, except as a punishment for crime, wherein a person shall have been duly convicted. And actually think a little bit about that phrase. Henry Hamilton may mention it during his presentation. Shall exist in the United States or any place subject to its jurisdiction. So no more slavery as of December 6th, 1865. Then the second of the three constitutional amendments commonly known as the Reconstruction or post-Civil War amendments states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. So that means all persons who were born in the United States are citizens of the United States and of the state where they live. So all these formerly enslaved people are clearly citizens of the United States and the state where they live. I didn't include all of the 14th Amendment. It's commonly known as the Equal Protection Amendment, and the amendment that clearly states the United States and nor shall any state deprive any person of life, liberty, or property without due process of law, nor shall deny to any person within its jurisdiction, in other words, within the United States or within any state, the equal protection of its laws. This section 2 should have served as an enforcement of these equal protections and this due process that basically says when the right to vote at any election is denied to any of the male inhabitants who are at least 21 years of age and citizens of the United States, which we know they are, is in any way denied or limited, the punishment should be that that state's elected representatives are reduced in number. The 15th Amendment, ratified on February 3rd, 1870, then clearly stated, the right of citizens of the United States to vote shall not be denied or abridged or limited by the United States or by any state on account of race, color, or previous condition of servitude. In other words, previously enslaved men, not people, not women, men could now vote. That right to vote is now clearly stated in the United States Constitution. Importantly, Section 2 of the 15th Amendment gives Congress the power to enforce this article by appropriate legislation. In other words, what Section 2 means is Congress has the right to pass laws to ensure that previously enslaved people, men, sorry, not people yet, men, or men of color have the right to vote, can actually vote. Let's fast forward again another 50 years to August 18th, 1920, the 19th Amendment, 100 years ago. Finally, we the people includes women. So the 19th Amendment states that the right of citizens of the United States, remember we said earlier that all persons who live in the United States or who are born in the United States or are naturalized are citizens of the United States. So that of course includes all women who are born or naturalized in the United States. So the right of citizens of the United States to vote shall not be denied or abridged or limited by the United States or by any state on account of sex. That's what gave women the right to vote throughout the United States. The 19th Amendment also includes this second section clearly stating that Congress has the power to enforce this article or this amendment by appropriate legislation, just to make sure that women, all women, have the right to vote and can actually exercise that right to vote. I'll add one more fun fact here before I turn it back over to Henry. The 19th Amendment was ratified by the Tennessee legislature on August 18th, 1920, the 36th and final state to do so. There were some attempts between August 18th, 1920 and August 26th, 1920 to rescind that ratification vote, which means to undo that ratification vote. But the 19th Amendment was added to the Constitution on August 26, 1920. So some of you may know or may have heard that August 26th is celebrated as Women's Equality Day each year. This is the reason why August 26th is Women's Equality Day. So here we are 100 years ago, but we're not done yet. We'll take you further back in time, and Henry Hamilton will describe what happened 150 years ago with the 15th Amendment.
Henry, you need to unmute.
Thank you, Emily. And now, once again, the views and opinions expressed by myself and my own are not to be attributed to any past, present, or future employer. Well, this year marks the 150th anniversary of the 15th Amendment. Prior to the 15th Amendment, the right to vote was largely restricted to, as you said, to white males over the age of 21. The 15th Amendment not only granted African American males the right, but it was one of the initial steps in the long journey toward universal suffrage. Today, I want to briefly talk about 5 things that folks should know about the 15th Amendment. One, Iowa made history when on...
Henry, I don't mean to cut in. Your audio is a little garbled. Could you mute and then unmute, or hit the disconnect audio and then reconnect and see if that helps?
Does that help?
Not yet.
What about now?
No, it's still got some reverb.
All right.
If everybody else could mute, I think that might help.
Oh, okay.
Sometimes that's an
I'll
easier
do that.
thing.
Yes.
I apologize. How's that?
Still have the same issue.
All right. Should we skip ahead and I figure out my problems and back to me?
Okay. You want me to, we can skip back 50 years and then come back?
So,
Okay.
before you do it, Henry, what you may want to do is disconnect from the Zoom and then rejoin. And let's see if that resolves it. Sometimes if you get a fresh connection. In the meantime, Emily, if you want to go ahead with your thoughts on the 19th Amendment, we can come back when Henry reconnects.
Okay, I'll do that.
And I do apologize to everyone for the technical difficulties.
Thank you all for your flexibility. Okay, we're skipping back forward. I think, there we go. Oh, actually, I needed to continue. So, the 24th Amendment passed January 23rd, 1964. Many of you may not know what the words poll tax mean. Henry will describe them in a bit, and Jerry will talk about some current issues with poll tax. And you might wonder, why is there a reason for an amendment to the U.S. Constitution to address a poll tax? A poll tax was a tax that was charged to some people, not all people, to try to suppress or create an obstacle to voting. You may note that the time period the 24th Amendment was passed, 1964, was in the midst of the Civil Rights Movement. So the 24th Amendment, as you can see, the right of citizens to vote shall not be denied or abridged by the United States or any state by reason of failure to pay a poll tax or another tax. And this all-important Section 2, Congress shall have the power to enforce this article by appropriate legislation. Then, the final constitutional amendment relating to voting rights, the 26th Amendment, July 1st, 1971. Finally, 18-year-olds are eligible to vote. You may recall that up to this point, a person must have been 21 years of age or older. You may also note the time period, 1971, right after the Vietnam War, where men 18 years of age or older were drafted to fight the Vietnam War and serve in the military, but they weren't old enough to vote. So this 26th Amendment gave 18-year-olds the right to vote. Okay, now let's go back 100 years to the 19th Amendment. I'll tell you some interesting facts about a number of women, most of them Iowa women, who were leaders in the women's suffrage movement. I'm sure many of you have heard of Carrie Chapman Catt. She was president of the National American Women's Suffrage Association from 1900 to 1904, and then for the final push for the ratification of the 19th Amendment, giving women the right to vote from 1916 to 1920. These are her words on August 26, 1920, the day the 19th Amendment was officially added to the United States Constitution. I hope these words inspire you, all of you who are at least 18 years old now, or will be 18 years old as of November 3rd, the next election. And of course, she's speaking to women who had just earned the right to vote. That vote of yours has cost millions of dollars and the lives of thousands of women. The vote has been costly. Prize it. Understand what it means and what it can do for your country. The motive of these women who had been fighting for the right to vote for 72 years, 72 long years, intended to use their right to vote to serve the common good. The vote is won, and you must act. Vote. In other words, she said, vote. Vote in every election. Use this right and honor these women who've worked so hard and so long to gain women the right to vote. Now, another leader in the women's suffrage movement, Alice Paul, was considered the radical woman leader in this movement. It was interesting because Carrie Chapman Catt grew up in Iowa, was educated in Iowa, and began her journalism career, almost began a legal career, and became a prolific speaker, organizer, and leader in the women's suffrage movement. Was very strategic and very deliberate, and tried to toe the line, or toe a narrow line, and make sure She didn't displease anyone too much, but also pleased the right people enough to win the vote. She was always focused on the end goal and did what she could to make sure it was achieved. Alice Paul, on the other hand, was very impatient with Carrie Chapman Catt's strategies. And so she was a bit more radical. So think about this. What Alice Paul did was more than 100 years ago. Let's compare some of the actions she took with some of the actions you've seen occur this summer across the country. So Alice Paul organized what was called the first picket, which means basically a protest using signs and banners. They protested right in front of the White House. In fact, she organized a group of women who stood outside the White House gates every day, basically 6 days a week, for 18 months, a year and a half, to persuade the current president, Woodrow Wilson, to support ratification of the 19th Amendment. They stood there, rain or shine, snow, sleet, and reminded him every day, because at the time the president actually walked in and out of those very gates right past those women holding their signs and banners. As you can imagine, President Wilson and many other men who didn't want to give women the right to vote were not happy about it. So Alice Paul and members of this women's party were arrested, jailed, tortured. They went on a hunger strike, so they were force-fed, and they went through this many, many times. So they were arrested because they were exercising their rights to protest. Another interesting fact, she organized the Women's March in Washington, D.C., right down Pennsylvania Avenue, right past the White House, the day before President Wilson's inauguration. This march included women from every state. Thousands of women marched in this parade. And in a moment, I'll tell you about one special woman who found a way to march in this parade with her state. So even though Alice Paul and Carrie Chapman Catt had very different ways to accomplish the same goal, it's interesting to see that Carrie Chapman Catt's words actually apply to these radical actions. Women suffered an agony of soul you could never comprehend, that you and your daughters might inherit political freedom. That boast has been costly, use it. In other words, vote. Vote in every election. Ida B. Wells Barnett was an active suffragist for Black women's right to vote. Remember that march I just mentioned? Ida B. Wells Barnett insisted on marching in this Women's March in Washington, D.C. with her Illinois delegation, with her state delegation. There was quite a bit of discussion ahead of this march that whether or not the march would be segregated. And unfortunately, thinking back 100 years ago, the organizers of this march insisted that Black women march at the back of the parade, and they couldn't march with their state. But Ida B. Wells would not agree with that plan. So she stood at the side of the march and then joined the parade when her state, Illinois, began to march by. In other words, she would not take no for an answer. Ida B. Wells was born in Memphis, Tennessee, and was a journalist there. She saw and heard of a number of lynchings. Her newspaper building was burned down because a number of white men were unhappy with the articles and editorials she wrote. Fortunately, she was out of town on a speaking engagement when that fire occurred, but that action persuaded her to move from Memphis, Tennessee to Chicago, along with many other African Americans who left the South and moved to northern cities at about that time. Here's some important words Ida B. Wells wrote in 1910. She was speaking about the unfair treatment African Americans received, in many areas of daily life, and specifically addressing these separate and inferior schools they attended. She connected these injustices to the fact that they were not allowed to vote. Like technically, as you just heard through the 15th Amendment, Black men should have had the right to vote, but this right was denied and abridged in many ways, as Henry Hamilton will tell you later on. But here's what she said. Please take these words to heart when you're thinking about exercising your own right to vote once you're old enough to do so. You can't complain against such legislation or such laws if you don't have the right to vote. You can't protest against such legislation, you can't choose other lawmakers, or you can't retire to private life those who legislate against your interest, unless you vote. This is what Ida B. Wells also said. With no sacredness of the ballot, there can be no sacredness of human life. She wrote this as part of an article responding to the lynching she's observed while she lived in Tennessee. She was a journalist, she was a women's suffrage activist, and she was eventually a candidate for public office in Chicago soon after the 19th Amendment became part of the U.S. Constitution. Another woman you may or may not have heard of is Arabella Babb Mansfield, another Iowan. She was the first woman lawyer in the United States. She grew up and was educated in Mount Pleasant, Iowa. She studied the law. Back then, women didn't attend law school, but they would read and study the law with a lawyer. She happened to study the law alongside her husband, John Mansfield, in her brother's law office. It was definitely a family affair. She passed the Iowa bar examination and was admitted to practice law in Iowa, or admitted to the Iowa bar on June 15, 1869. She never actually worked as a lawyer, but was active in the women's suffrage movement, chairing the first Iowa convention in 1870, and gave many speeches on women's suffrage in Iowa and in other Midwestern states. Coincidentally, her sister-in-law, Alice Bird Babb, was also a prolific women's suffrage speaker. And Alice Bird was one of the 7 founders of PEO, also in Mount Pleasant, Iowa in 1869. Some of your mothers may be PEO members. Another Iowan that who may have a familiar last name, but you may not have heard of as associated with the women's suffrage movement, is Annie Savory. She was the first woman to speak publicly on women's suffrage in Des Moines and in Iowa City in 1868. Annie Savory's husband was a very successful businessman in Des Moines, and she was part of what was considered the high society in Des Moines back then in the 1860s, 1870s. So she used her position to attract the attention to the importance of women's right to vote. She was also one of the first 3 women to attend the University of Iowa Law School and to become a lawyer. She became a lawyer not to practice law or represent clients, but to understand the legal history of women's rights more fully to support her work in the women's suffrage movement. And the reason her last name may sound familiar to some of you, if you visited Des Moines for a state athletic tournament, it's the Savory Hotel in downtown Des Moines at 4th and Locust was owned by Annie Savory and her husband. So you can think of her and her hard work for the women's suffrage movement next time you visit the hotel. The last person I'll mention isn't a native Iowan and isn't a woman, but he was a very important part of the final ratification of the 19th Amendment. And he exemplifies the importance of voting. The fact that every vote matters and every voter matters. Remember I mentioned that the Tennessee legislature was the final and 36th state to ratify the 19th Amendment. During the summer of 1920, the Tennessee state legislature gathered, and many representatives of the women's suffrage movement gathered there to persuade the Tennessee legislators to vote in favor of the 19th Amendment. Harry Byrne was the youngest member of the state legislature at only 24 years old. He personally believed women should have the right to vote, but he believed his Eastern Tennessee rural constituency did not support it. He was torn. But on the morning of August 18th, the morning of the final vote, he received a letter through the United States Postal Service. Again, let's compare what happened 100 years ago to what's happening today. He actually received that letter at his desk shortly before the vote. My slide says exactly what his mother's letter said. Dear son, hurrah, vote for suffrage. Don't forget to be a good boy and help Mrs. Cat put the rat in ratification. Lots of love, Mama. That made up his mind, his mother's letter. He voted in favor of the 19th Amendment. That one vote made all the difference. So always listen to your mother's advice, your mother's good advice, and make sure you vote. I'll now turn it back over to Henry Hamilton to take you back in time another 50 years to talk about the 15th Amendment.
All right, I trust this is much better. Great, all right, sorry about confusion before. So this year marks the 150th anniversary of the 15th Amendment. Prior to the 15th Amendment, as Emily said, the right to vote was largely restricted to white males over the age of 21. The 15th Amendment not only granted African-American males the right to vote, but it was one of the initial steps in the long journey towards universal suffrage. For the remainder of my presentation, I want to talk to you about 5 things you need to know about the 15th Amendment. First of all, Iowa had an important role in the passage of the 15th Amendment. Iowa made history when on February 3rd, 1870, the Iowa legislature approved the 15th Amendment. The amendment required 3/4 adoption of the states. Iowa was the 28th state to ratify the amendment of the 37 existing states at that time, thereby ensuring its ratification and going down in history as the last state needed for ratification. With that said, Iowa's support of the 15th Amendment was not really a major surprise. 2 years earlier in the state of Iowa, at the urging of Alexander Clark, who was a well-known civil rights activist, and others, Iowa electors voted to give suffrage to African-American males by removing the word white from the state's definition of qualified electors. The Iowa Constitution at the time, like the Constitution of many states, provided that only white males over the age of 21 could vote. Well, Clark had just recruited a bunch of African Americans, not only in the state of Iowa, but throughout the Midwest, to fight for the Union in the Civil War. So after the war is over, Clark says, hey, we fought, we should have the same right as everyone else. And he famously stated in 1868, he who can be trusted with the army musket shall also be trusted with that boon of American liberty, the ballot. And in 1868, the Iowa voters agreed with him by a margin of 56.5% in favor of allowing African American males the right to vote. The second thing I want to bring up is that the 15th Amendment, although a major advancement for voting rights, adding millions of people to the voting rolls, was the product of a major debate and significant compromise. And just like with any other law passed, you don't always get everything that you want. So to take you back as Emily did, so following the Civil War, you have the 13th Amendment, you have the 14th Amendment, but even after these, the passage of these amendments, there was still work to be done to ensure full participation in this American democracy, this American experiment by African American males. African Americans still did not enjoy equal voting rights. And as Frederick Douglass eloquently observed, slavery is not abolished until the Black man has the ballot. While legislatures of the South retain the right to pass laws discriminating between Black and white, slavery still exists there. And to underscore what he was saying, you know, you always hear that we are a government of the people, by the people, and for the people. Well, in America, one of the best ways to express your will is through the ballot, by voting and electing representatives. Well, politicians primarily serve two purposes. They pass laws and they distribute money. If you have no sway with politicians, you know, it could be likely that your interests will be ignored or at least come further behind other people's interests. So Frederick Douglass, Alexander Clark, Sojourner Truth, and others realized that they had no say in the representatives in this form of government. Well, those governments will be free not to enslave them, but to enact so many restrictions and to not give money to their parts of the community that they would not be enslaved, but they would be just notches below slavery. So the 15th Amendment was the last of the three Reconstruction amendments. Some of the more, I talk about the debate, some of the more progressive versions of the 15th Amendment sought to extend the right to African Americans while also prohibiting voting qualifications based upon education, property, and wealth requirements. The proponents of the more progressive versions feared that states would use education and wealth requirements as proxies to disenfranchise the African American males within their borders. In the end, a more moderate version of the 15th Amendment was passed that Emily showed earlier. The 15th Amendment, like I said, extended the right to vote to millions of African American men who otherwise would have been prohibited from voting simply because of the color of their skin. While it's important to recognize what the 15th Amendment did, it's also important to reflect on what the 15th Amendment did not accomplish. The 15th Amendment did not provide a universal right to vote. In fact, Americans still do not enjoy a constitutional right to vote. The 15th Amendment only provided that to the extent the federal government and states provided the right to vote could not be restricted because of race. The 15th Amendment, as Emily said, did not guarantee women the right to vote. Women were not extended the right to vote until passage of the 19th Amendment. And on that point, African-American women would not effectively enjoy the rights until the passage of the Voting Rights Act of 1965. The 15th Amendment did not grant 18-year-olds the right to vote. 18-year-olds would not enjoy the right to vote until the passage of the 26th Amendment in 1971. And most importantly, the 15th Amendment did not prohibit the states from restricting the right to vote because of education, wealth, property, or other so-called facially neutral qualifications. And as predicted, states exploited this weakness within the 15th Amendment to disenfranchise African-American voters. The third point I'd like to make is that the 15th Amendment had a significant impact, but its immediate success was short-lived, and for many decades thereafter, the amendment was largely ineffective in securing voting rights for African-Americans. After ratification, Congress quickly passed laws empowering the federal government to ensure the constitutional guarantees of the 15th Amendment by criminalizing efforts to suppress the African-American vote, particularly through violence. Prior to the 15th Amendment, there were no federally elected African-American officials and only a handful in state and local jurisdictions. African-Americans began serving in the U.S. Senate and the U.S. House of Representatives immediately after ratification, indeed the same year. From 1870 to 1900, 22 African Americans had the honor of serving in Congress. Like I said, the success was short-lived. The 15th Amendment fell victim to Supreme Court action and exploitation of its internal weaknesses. In a series of rulings, the Supreme Court held that the 15th Amendment did not grant Congress the power to curtail efforts by private groups. So what did this mean? Well, it meant that Congress had little authority to prevent private groups, the Ku Klux Klan, white supremacists, related militias, from interfering with African-American vote. Emboldened by these Supreme Court rulings, these groups engaged with impunity in wholesale domestic terrorism against African-American voters and their white allies. For instance, from 1887 through 1968, 3,446 African-Americans were lynched. For African-Americans in large part of the nation, voting was elevated to a life or death decision. From 1881 to 1967, no African-Americans served in the U.S. Senate. Meanwhile, the Supreme Court held that facially neutral restrictions on the right to vote were legal. Several states took advantage of these rulings and exploited the weakness. States utilized poll taxes, education requirements, literacy tests, grandfather clauses, and understanding clauses to disenfranchise the African-American voters. Now, why this was hypocritical or ironic, these same states that required education requirements, these were some of the same states that just years earlier had anti-literacy laws preventing the teaching of reading and writing to enslaved persons. In fact, even in states where education of African Americans was allowed, African Americans were segregated, provided inferior facilities, supplied with outdated learning materials, if any materials at all, and were also were otherwise subjected to unequal educational opportunities. And these tests were not administered equally. And if I can, I'll attempt to test the limits of my technological experience here. But yeah, these tests were not administered equally. For instance, here's one from Mississippi. And if you read 18, you will see that the registrars had wide discretion on who would pass and who would fail these tests.
And
for instance,
would you like me to share the screen share?
Oh, Yes, please.
Okay.
Sorry. All right. So they had wide discretion. Is it showing now? Next slide. Next slide. Okay. Is my screen showing? John, you're on mute.
I don't know what's up there right now.
Okay. I apologize.
I think, John, Frederick Douglass is up right now, and what you probably want to show is the
Okay.
third slide.
That one?
Oh, my screen sharing is, okay. Okay, so here you have the Mississippi question in number 16, and it shows that these registrars were given wide exercise in who would pass. You can see the vagueness of it. So in the end, next slide. So a white applicant might be given a passage like this, section 20, that no person shall be imprisoned for debt. Next slide. Whereas a black applicant would be given a question something like this. Poll taxes, okay, that's it. Poll taxes also pose significant barriers to African Americans, since until recently, African Americans had largely not been paid for their labor and did not have significant opportunities to accumulate wealth. So the combined effect of the Supreme Court rulings, domestic terrorism perpetuated by the white militias, and an employment of discriminatory tests and poll taxes drastically reduced the African American vote by making voting illegal, life-threatening, and otherwise more difficult. In Louisiana, in 1896, 130 African Americans were registered to vote. By 1904, that has shrunk to 1,342. Likewise, in Alabama, 180,000 African Americans were registered to vote. That has shrunk to 3,000. By 1940, in the South, only 3% of eligible African Americans were registered to vote. My fourth point, the greatest legacy of the 15th Amendment is the Voting Rights Act of 1965. Congress enacted the Voting Rights Act pursuant to its authority in the 15th Amendment. And the major thing, and I'll speed up here, the major component of the Voting Rights Act I'd like to talk about is preclearance. For many years, the federal government had been becoming more and more aggressive in its efforts to stop voter suppression. It had failed. Finally, in 1965, they came up with preclearance where certain states, particularly the states that had engaged in discrimination in voting, if they were to make any voting changes, they would have to get these voting changes pre-cleared by the Department of Justice or the DC Circuit Court. That move there to where the states could not enact a discriminatory practice until it was approved had tremendous success. From African American voting went from 10% in Mississippi in 1964 to 60% in just 4 years. Likewise, in Alabama, the percentage before the Voting Rights Act of 1965 was 24%. That jumped to 57%. By 1970, 5 years after the Voting Rights Act, almost as many African Americans were registered to vote in Alabama, Mississippi, Georgia, Louisiana, North Carolina, and South Carolina as had been in the last 100 years. My last point my last point I want to make is that the protections of the 15th Amendment are under attack again. In 2013, the United States Supreme Court ruling in Shelby County versus Holder essentially eliminated the pre-clearing process that I just explained. Covered jurisdictions, including states, even states with notorious histories of racial discrimination, were relieved of the obligation to submit voting changes to the Department of Justice and the DC District Court. States waited little time in acting measures. In the time remaining, I just want to talk about one issue that is ongoing, and that's the waiting lines. And there's the waiting lines are going. A 2019 study by researchers from UCLA, Carnegie Mellon, and University of Chicago found substantial and significant evidence indicating that evidence of racial disparities in voter wait times. The same study cited evidence indicating that 3% of voters will leave polling locations without voting when faced with lengthy voting lines. And also a 2018 survey, a study by Harvard University, said that not only is that election impacted, but the next election is impacted. 2 to 3% of the folks not voting in a subsequent election stated that the reason they did not vote was because of the long lines in the previous election. And this is key because after Holder, the Leadership Conference on Civil and Human Rights reported that between 2014 and 2018, those covered jurisdictions utilized 1,173 fewer polling places, even in the evidence of increased voter turnout. So those are the 5 things I'd like to, that you should know about the 15th Amendment, and I'll close now. But as we continue celebrating the 150th anniversary of the 15th Amendment, the 100th anniversary of the 19th Amendment, and the 55th anniversary of the Voting Rights Act of 1965, we should look back in appreciation of how far we've progressed as a nation. At the same time, however, we must remain steadfast in our efforts to protect equal access to, quote, the boon of the American liberty, the ballot. We will not become that more perfect union by accident. It will take work. Thank you. And with that, I believe President-elect Anjela Shucks.
Thank you, Henry. And again, thank you all for participating. I'm going to talk very briefly about the current issues, and in particular, the 26th Amendment. And I think that this is the one that I think has a ton of significance as many of you reach the age of 18. As Emily talked about and as Henry talked about, up until this time, you had to be 21 in order to vote. The conversation for the 26th Amendment started actually back in the 40s. And when FDR, Franklin Delano Roosevelt, lowered the age of the draft from 21 to 18 during World War II. And it was then that the conversation started. It was that the slogan started, old enough to fight, old enough to vote. Georgia actually was, interesting enough, the first state to lower the state voting age from 21 to 18, and that occurred in 1943. The first legislation, the first attempt to lower the voting age was introduced in 1942, and I point that out just as an example of that it took almost 30 years for the idea of lowering the voting age from 21 to 18 to catch on. So initially it was introduced in 1942. The conversation really intensified during the Vietnam War, and particularly when many young people, again, were drafted at the age of 18 and sent to Vietnam to fight, but again, they could not vote. in March of 1971, federal legislation was passed to ratify the 26th Amendment. And ironically, despite the fact that it took 30 years to get passed, it only took 2 months to ratify. So the legislation was passed in March and it became effective July 1st. And again, ironically, I find this very ironic, President Richard Nixon, a Republican, signed that legislation, signed the amendment into law on July 5th, 1971. It was not only just President Nixon signing, but it was the fastest ratification ever of any amendment. And so I know that the conversation that has started to be approached about whether or not perhaps the voting age should be lowered to 16 as, old enough to drive, old enough to vote. And I would tell you, the conversation while starting, it may take some time, but it certainly is worth the conversation. So with that, I'm going to turn it over to Jerry Schnurr to take us into a little more current issues and bring this home a little bit better.
You're on mute, Jerry.
We're loving technology and Zoom. Thank you, everybody. I want to just touch briefly on some issues regarding felon voting rights and then close votes in Iowa. In Iowa, the governor has recently signed an order allowing those convicted of felonies to vote if they have served their sentence, including parole and probation. In Florida recently, a similar language was used in a constitutional amendment. The voters in Florida approved that amendment to allow convicted felons to vote if they completed their sentence, including probation and parole. That was passed by about 65% of the voters in Florida in 2018, I believe. Shortly after that, the Florida legislature passed a statute that said in order to vote, felons had to pay their fines, their restitution, and fees. This goes back to poll tax and other fees, right to vote, as we pointed out in the 24th Amendment that was passed. And so many believe this is a violation of that amendment, and that is currently being litigated in the courts. The status of that is that the federal district court in Florida said that this statute was unconstitutional. It was appealed to the the appellate court, the 11th Circuit Court of Appeals. The 11th Circuit Court of Appeals has stayed the decision, so said the decision of the district court saying it's unconstitutional, we're going to wait and enforce that. So the statute is in place. Now, that puts a lot of former felons who want to vote in jeopardy, because if you vote and you owe fees and costs and fines and restitution, you could be voting illegally, and it's another felony. And it's sometimes difficult in Florida to find out what you may owe for fines and restitution because of no centralized record keeping, and some counties being very poor in keeping their records. So you don't know if you owe anything or what you may owe. So in order to, another wrinkle in all of this is there's been an effort by some prominent people, LeBron James, John Legend, former Mayor Michael Bloomberg, to raise money, and they've raised about $20 million to help pay off fines and costs and restitution for convicted felons in Florida that have otherwise served their sentence. And that is being challenged also then by the Florida Attorney General, who thinks that is arguing that it may be an illegal way to try and buy votes. And the response from those raising the money is that they're not asking people to vote any particular way. They're just giving them the money to get over that hurdle so that they can vote. Henry mentioned the reduction of polling places. That's an issue that's going on in the long lines. People get discouraged or feel threatened. Another that happened in Texas recently is the governor declared that drop-off boxes for mail-in ballots will only be one per county. To put this in perspective, the county where Houston is located is about the size of the state of Rhode Island, and there are over 2 million people that live in that county. So we have one place where you can drop off your ballot, early ballot, in Harris County, where Houston is located, and it would be like saying the state of Rhode Island. You have one place where you can drop off your early ballot. There's a decision that recently came out from a district court in Texas that said that may not be legal, it may not be constitutional, and has struck that order down. Now, I don't know what's going to happen if and when that's appealed. I just want to touch then briefly on close votes, because your vote matters. It's been said, I think, by just about everybody here. Every vote matters, everybody counts. In Iowa, and there's dozens and dozens of these types of cases across the country. In Iowa, in 1918, a United States House race was decided by 4 votes. Now that's Congress. That's somebody running for Congress, was decided by 4 votes. Just in the last election in 2018, there was a race in Northeast Iowa for the Iowa House of Representatives, covering, I think, parts of Poweshiek and Fayette County in Northeast Iowa. There were about 52,000 votes cast in that election. There was a dispute over whether 29 mail-in ballots should be counted that went to the Iowa House of Representatives, ended up in court. That race was ultimately decided by 4 votes. 4 votes? And I'm sorry, 9 votes. It was ultimately decided by 9 votes out of about 52,000 votes. So your vote counts. It's very important. We encourage you, if you're 18 or if you will be 18 on November 3rd, to register to vote, get information about the issues and the candidates, and then go exercise your right to vote. It's a great way to honor all those you've heard about that have gone before you and sacrificed and fought so hard to earn the right to vote in these elections. This is your way to express your voice and elect people you want to represent you in the school boards, on the county commissions, in the State House, in Congress, and in the White House. So I want to thank you all for your time today. And we encourage any questions. I'm going to turn it over to John Wheeler, but we encourage any questions, submit them through chat, and we'll be happy to respond to any questions you might have. Thank you so much.
Thank you. Again, as Jerry mentioned, you can submit any questions you might have in the chat function while you're furiously typing away. The historian in me has a question. That's the great thing about being the host, is my question always gets asked, although rarely answered. So when Emily was pointing out the various provisions of the 15th Amendment, there was a line in there that said something about that any state that violates the voting rights would be potentially penalized by losing representation in the House of Representatives or in Congress. Have any states ever been punished that way?
Not that I know of. That's what I think was so interesting about it. You know, once I read, it seemed that it was unenforced, as as you've heard, you know, many of the voting rights protections were largely unenforced for a number of years. What I found more interesting, I guess, that is the fact that it existed and this was actually the 14th Amendment, part of basically the Equal Protection Amendment. So a provision was included to try to enforce this right to vote, but it wasn't actually enforced that I know of.
And on that point, one of the conditions of the former Confederate states was they had to adopt the 14th Amendment and grant African Americans the right to vote in order to be admitted back into the Union.
So, Henry, in your presentation, you mentioned about the pre-clearance requirements of the Voting Rights Act, and then the subsequent removal of those pre-clearance requirements by the Shelby decision in, was it 2013?
Yes.
Okay. So, what exists now if a state were to violate either a segment of the population's voting rights or an individual voting right?
We're back to the processes that took place before the Voting Rights Act of 1965, whereas in a state would it'd be alleged that a state violated African Americans' rights or some other subgroup during the election, the federal government would sue. The court would rule in favor of the federal government. But you got to understand, these cases take time. So by the time that there's a decision in a matter, that election is over. Those individuals are already serving in office. And furthermore, 2 or 3 elections may have taken place. So that's what we're back to. Now, as part of relief, if a state or another jurisdiction is found to have discriminated against African Americans, a court can order that state to submit any further changes to the Department of Justice or to the DC District Circuit. I don't think that's taken place to the best of my knowledge yet.
And then, Angie, during your presentation, you mentioned that the struggle to lower the voting rights went from 21 to 18 dates back to the World War II, and that in fact Georgia had taken individual action to lower their voting age requirements way before many other states. Is there anything now that would prevent a state individually or independently to lower the voting age to 16, or is that now a federal matter?
I think it's still a state matter, and that's part of the problem, I think, why the constitutional amendment had to happen. Because there was a Supreme Court case in 1970 that indicated that the states, because I think the issue was that there was this conflict between the federal government and the state governments, that the federal government wanted to prevent states from lowering the age. And then the U.S. Supreme Court case said, no, the states can do that. They can set their own voting age on state, and so that's what happened at that point in time. I also want to make mention as far as, just the voting rights or just voting in general is a lot of times it relies on the federal government and the Department of Justice to enforce those rules, and those Department of Justice makes that a priority. So, or it has not.
John, if I could just piggyback off of something that Jerry said, assuming I can get my share screen to work this time. Okay. Oh. I'm going to get it 1 second here. Jerry talked about the poll taxes and how individuals were were putting up money to pay for other individuals' poll taxes. Well, we're revisiting this now because back in the 1960s, you had individuals that did the same, that would offer to pay for the poll taxes of individuals who otherwise could not afford it. I believe now, I'm showing my screen, but that's a Vernon Dahmer. And on January 9th, 1966, Vernon Dahmer advertised on the radio that he would pay for the poll taxes of anyone that was willing to vote. Well, on January 10th of 1966, the very next day, he was burnt alive for making that offer. And the photo to the right, we have who was then the one of the grand wizards of the Mississippi KKK in 2006. He was brought to justice 40 years after murdering Vernon Dahmer because of that promise to pay everyone's poll taxes. Now, the happy ending to this story is that in 2018, outside the Forest County courthouse in Mississippi, they've erected a statue of Vernon Dahmer. He would always say, if you don't vote, you don't count. And so some 50 years after his death, there's a statue of Vernon Dahmer. And so that relates to Jerry's comments earlier about how we're seeing some vestiges of the poll tax even today.
I'm not seeing any additional questions on the chat. If anyone has another question, please feel free to ask it.
It looks like there's a question. What's the reason for decreasing the number of polling places and absentee ballot drop boxes? Voter suppression question. Anybody want to take that on? Henry,
well, I can't talk.
Yeah, you kind of talked about it with the long lines. It's in line with what happened in Milwaukee and so forth.
Yeah, and I don't want to particularly discuss people's motivations, but the impact of not giving enough ballots to polling locations in urban communities where I've seen times where you actually have to stop. A person has to run back to the election office and bring ballots back. The purposeful placement of outdated and dilapidated voting machines in urban and largely African-American communities, and also the decreasing of polling places. All these things work together regardless of the motivation to create larger lines. And we now know that these larger lines deter people from voting, not only in the current election, but in elections going forward. And that, to me, is one of the major attacks of the 15th Amendment and the Voting Rights Act that we need to undertake. Like who among us can wait in line 3 to 4 hours to vote? But it takes place every election and in largely African-American communities.
I guess I'll join into the simple answer to her question is yes. I guess I'll be frank and say that there's no other plausible reason to decrease the number of drop boxes or decrease them to the level that they're decreased in some states. And then here in Iowa, the efforts to decrease the number of drop boxes in each county or the locations of those drop boxes. For example, I believe it's Lynn County, the Cedar Rapids area. The county auditor had a ballot drop box outside of a Hy-Vee store because, of course, not not advocating for any particular, maybe I'll say a large grocery store chain, but that's where people are going. You're going to the grocery store to shop, so that's an easy, convenient place to take your ballot and leave your ballot. So those were, that was not allowed, just beginning this summer with this election, and county auditors in Iowa can only have ballot drop boxes at their office location. So basically one place, in each county. So just like Jerry was mentioning for the Harris County and the Houston, Texas area. And then the decrease in polling locations, I guess what I've heard from a county auditor and the Iowa Secretary of State is mostly due to the pandemic, that to ensure safety and distancing and all those considerations, that polling places that were traditionally used aren't available this year for all kinds of practical reasons. So that's one reason for the lesser number of polling locations within Iowa. But to make up for that possibility of long lines, the county auditors are heavily encouraging, strongly encouraging absentee ballots voting, and then early voting in I believe every county in the state of Iowa.
Yeah, one of the issues that always comes up with that and with voting on election day in general is that people that have hourly jobs or work may have a hard time getting away from work to go and vote. And so that's why so many people believe it's important to have voting places and polling places open at times other than during normal work hours, so that folks that have hourly work can get away and can vote. Thank you for the question. That's a good question.
I think we're close to our ending time. So I'd like to invite the panelists for one final comment or hand it back over to Jerry.
Just one final comment. Vote. Every vote matters. Every voter matters. You matter. Vote as soon as you're eligible, and vote in every election, no matter what, one way or the other. Thank you.
Yeah, I'd like to echo that. Please vote. Folks your age have been responsible for making a lot of good changes in this nation. We saw a lot of young folks talking about political issues within the last 2 years. We hope you maintain that enthusiasm. But if you don't vote, nothing will change. Vote.
And as I tell my teenage daughters who are biracial, that there were lots of people who fought for them to have the opportunity and the right to do it. And so do not disappoint them. And do not disappoint your mother either. Thank you.
I couldn't say it any better. Get out, vote, take your friends, your family members, your mom, dad, uncle, grandparents, neighbors, get out and vote at every election, from the school board to the president. Vote, please. This is your country, this is your community, and you young people are the future. So this is your chance to express your voice. Thank you very much, and we look forward to seeing you again.
I want to thank our panelists and thank our participants. Whether you're watching this live or whether you're watching this on a tape, know that that this is the first of a series. We hope to have additional civic education and law panels available throughout the school year. All resources, materials, videos, including the video of this presentation, will be posted on the ISBA website. And one final thing before I stop the recording, a shameless advertisement for another Iowa State Bar Association program. We invite high schoolers around the state of Iowa to participate in the Know Your Constitution program. If you visit iowabar.org, and click through the public education links to get to information on that. It's a 50-question multiple choice open book quiz with an essay question and a chance to win some fabulous prizes. So with that, thank you again to Jerry, to Angie, to Henry, and to Emily, and thank you for joining us today. And I think we're out. Thank you so much. I'm going to go ahead and end this Zoom session.